The construction industry has come under focus for alleged anti-competitive practices. What is the process that is being followed by the Competition Commission to get to the bottom of these allegations?
We initially started with some research and scoping studies in the industry and realized that there was a lot of what appeared to be anti-competitive conduct in construction. And then there were initial investigations, one or two standalone investigations, which also showed that actually this problem goes, much deeper than those few firms. And so once again, there was a desire to design a process where we can get as much information as possible within also a relatively short period of time. So the construction fast track process was designed for companies to come forward, disclose projects where they've engaged in anti-competitive conduct, and then they would be penalized for that within certain bands. But of course, the penalty would be lower, not low, but would be lower than the case would have been if we had to go through each project and investigate it, and in each instance impose a penalty which is potentially up to 10% of total turnover. In this case, it would be related to the category of type of construction involved. It wouldn't be related to total turnover, and they would all be put into one basket. So in that sense, we have been able to get a lot of information. We've had over 20 companies disclose over 130 projects. So it's been useful in that sense. It's lenient, but not overly so, because they would still get penalized. They would still sign a consent order that would be confirmed at the tribunal, where it's clear that they've been guilty of this conduct, so it's out in the open. If they offend again, that would have been taken into account. And also the clients of those contracts that had been rigged also have an option on their own accord to pursue damages claims in the civil court. So there's quite a lot of repercussions that will follow from this process. Okay. But it's going to be, it's taking us just a few years relative to if we'd spend the next decade or however many years trying to unravel the sector. I think another important principle here is that we're trying to help the sector to move forward from this and to eliminate anti-competitive conduct. Especially as we go into a major infrastructure program spend. So the idea is not so much that it's all about punishment, but more, almost transforming the sector from a competition perspective so that it can move forward from that. So in future, government and also private sector clients would be paying fair amounts for the services that they procure.
And then, as reported in the media recently, it seems that criminal investigations of the construction industry may be pursued by the Hawks. Is there any link between the Commission's processes and the criminal investigation?
No, not in terms of the processes, because we're basically working within the competition law framework, and we are prosecuting in that sense, and we would be getting a financial penalty at the tribunal when the settlements are confirmed. Okay. It's all about the firm, and it's not about individuals. It's not about fraud, racketeering, corruption, etc. So in that sense, they're very separate processes. Okay. But obviously, I think conceptually, bid rigging is criminal activity in the way that it's done, in the deception to the client, the misrepresentation of information, the pretense of competition. So all of that will definitely, and also payments going back and forth between the winners and the losers. So there is a lot of criminality involved, but it is for the criminal enforcement agencies to take it up and use their own powers. And obviously the standards of evidence, etc., are different between the administrative system and the criminal system. So they will be pursuing it in that, and they will be doing their own investigation, gathering information. So yeah, there isn't really a link in terms of the processes.
Okay. And then in terms of the Commission then, how do you monitor that these companies do not engage in these irregular conducts again?
Well, in general, I think we try to scope industries where we think there are problems and do high-level studies. We monitor conditions we impose on mergers. We monitor remedies that are imposed in enforcement cases. So I think, you know, that there are those mechanisms that would be there. In construction specifically, there are also policy instruments that are recent, but that we think going forward would help. For instance, in procurement, there's now what's called a certificate of independent bid determination, where a company, when it's putting together a tender, has to state that this is its own independent proposal. It hasn't collaborated with anyone else in putting it together. So that sort of thing, I think, makes it, raises awareness from the person who's putting the proposal together that this is criminal conduct, if that's what they were contemplating to do. But then it also makes it strengthens the case where collusion is found, that you not only colluded, but you had actually made a representation that you were not going to collude, that you were going to be independent. So I think tools like that going forward will help. National Treasury also has mechanisms that it can use to penalize those companies defrauding the state. And I think I think they've always used them. Going forward, they'll probably be more scrutiny on that. I think as our work gains more prominence, the private sector would also bring cases where they've been victims of anti-competitive conduct. I mean, I think that's one of the things that the construction fast track, once we're ready to talk about our findings, will show that it wasn't only public sector victims in terms of the clients, but there were also things like shopping malls, hospitals, industrial plants that were procured by the private sector, and they're also becoming victims of anti-competitive conduct. And so we hope that they would also be instrumental in raising the alarm.
And speaking of these various bodies that can actually help with this initiative, which are some of those that you think you can actually build a very close relationship with in order to reaching the mandate?
We already have a very good relationship with National Treasury in terms of our procurement work. We've done quite a bit of training in state-owned enterprises, but I think we still need to do more, but because they're also very critical as people who spend a lot of money within the economy. We have good relationship with business associations where we go and present information, and they've taken it on board. So for instance, BUSA is quite active in advocating to its members about anti-competitive conduct. There've been lots of ethical pacts in various industries where, you know, it's anti-competitive conduct is one of those things that the industry says it will frown upon and make it difficult for those individuals who are found to do this to progress in their careers. So I think those sorts of institutions have been helpful.